And if you would read Baz Muhammad Kakar's case, in which it was specifically said where the constitution or a statute does not provide a right of appeal, there is no right of appeal. And if you want to provide a right of appeal in the constitution in exercise of constitutional powers, those have to be provided by a constitutional amendment. And if you want to provide a right of appeal in a statute, then the statute has to be amended, because this right is a creature of the statute or the constitution. And unless the instrument which provides the appeal, or unless the law that has to provide the appeal, it is amended, it cannot be provided by implication.
Mr.
My lord,
Mr. Zaid Ibrahim. Over here.
चले आप अपना पॉइंट्स तो बताएं ना, हम कुछ नोट ही नहीं कर रहे हैं. I'm not writing anything. I'm just hearing various queries. I mean, can you complete your submissions?
I hope
Please complete your submissions, and then you can respond to all the queries.
in relation to
Zaid Ibrahim,
Ji, my lord.
if I may. On your reading of entry 55, would it be possible for Parliament to make a law creating an intra-court right of appeal in respect of an appeal heard by the Supreme Court under Article 185? Would that be permissible?
Your lordship has perhaps dealt with that question, where your lordship has even said, well, the line that, and in the end, there must be an end.
No, that's review. But I'm saying, क्योंकि आप जिस तरह entry 55 को पढ़ रहे हैं ना, review का तो हमेशा ही है. And my question is, on your reading of entry 55, would it be permissible for Parliament by an act to provide for an intra-court right of appeal in respect of judgment delivered by the Supreme Court under while hearing an appeal under Article 185? Would it be possible on your reading of entry 55?
My lord, that would go against the finality principle, because
Yeah,
right of
always.
appeal
Again,
against right of appeal.
इधर आप
But
अगर-
the logic is
अगर
that here there is no
अरे
appeal.
enlarge करके भी तो देखिए ना, अगर ये section 5 जो है valid है, if it
जी.
is intra vires, petition under 184(3) is filed, whatever happens, appeal is filed, whatever happens, there is a right of review against that.
Okay, so let me
मेरा
answer.
आप-
देखिए,
आपका
जो
सवाल-
intra-court
मेरा
appeal,
सवाल-
intra-court appeal is original jurisdiction, never appellate jurisdiction. Intra-court appeal, so there'll be two streams. One is the original jurisdiction of the Supreme Court. When a special single judge of the High Court passes an order, that is original jurisdiction of the High Court he is exercising, provided under intra-court appeal. So that scenario may not be here at all, because 184, 185 is already there. We are only concerned with one kind of appeal, which is 184(3) appeal, nothing more.
No, I think
I understand your lordship's question, and let me answer it.
आप जितना broadly entry number 55 को पढ़ रहे हैं, तो उसकी implications है ना.
जी.
अगर उसकी implications fail कर जाती हैं, तो that's one thing. उसकी implications alive रहती हैं. That तो इसलिए समझने की बात है ना. या तो आपका केस है कि जी appellate jurisdiction में नहीं हो सकता, further ये power खत्म हो गया, मुझे तो फिर नजर नहीं आता उसमें कोई ऐसी limit.
मैं ये नहीं कह रहा, मैं वाज़ेह तौर पे ये कह रहा हूँ कि जहाँ तक power of enlargement hai, that exists not just in relation to 184(3), it exists. And my answer is, the line that in the end there must be an end, unless the Parliament says so. Unless the Parliament says so. That is my.
You're adding words to my words.
Yes, indeed. I'm taking the liberty of adding the words, unless the Parliament says so.
I may or may not agree with you.
Subject to your grateful, sir. Sir, if I may move to the next point, this challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My lord, I will not make your lordships read, but I'll just cite the relevant paragraphs of a few judgments. My lord, the first is the Sharaf Faridi case, PLD 1994, Supreme Court 105. at page 107.
Please repeat the citation.
My lord, PLD 1994, Supreme Court 105,
At
107.
okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61,
No, Supreme.
The 2010 Supreme Court.
page 61. This is my Lord Chief Justice Iftikhar Mohammed Chaudhary versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants, which also define what independence of judiciary is, I have taken the liberty in my concise statement in paragraph 10. I have drawn out what these international treaties say. I will just read one sentence from there, my lord. Independence of judiciary, according to the Council of Europe recommendations, says the principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is the first definition of independence of judiciary that I was able to gather, which specifically says that from internally from the institution, there has to be independence. My lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners, how independence of judiciary is diluted by this law. An argument is certainly made that once we open this door and allow the parliament to legislate in relation to even the practice and procedure of the Supreme Court, tomorrow the parliament may make another law. My lord, when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so, but not at present. This law does not. My lord, most humbly, under Article 184.3.
Zaid Ibrahim, how do you say that? Where the act obligates the Chief Justice or two other judges to act in a certain manner, and as was rightly pointed out by one of the counsels, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the parliament will now dictate how benches are to be formed or how what cases are to be fixed by the committee or by the chief justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
My lord,
I think
your
this is
lordship will give.
I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So if I, yes, it is premised, but if I use the term independence of judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and not use the word judiciary. And then the argument goes back and forth, the same one, he's the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say. Use not the word independent, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
Two very brief responses. Your Lordship should give credit when this law was being debated in Parliament. The very point that your Lordship has said was also raised. And they said,
In
and,
fact, incidentally,
and
there are two orders of this court, and the learned Attorney General also undertook to place on record
वो
the
तो,
debates,
in
which
an
have not
earlier,
been placed.
my lord, in an earlier hearing, it was
Fair enough.
pointed
So,
out that
I
it
mean,
is available online.
If that order
I
had
think it's
been
been placed
complied
by
with,
one of the lawyers. It's available in CMA 8565.
I
One day's
think
debate
it's a
has been
good
placed.
150 pages.
Some parts of it have been
Acha,
placed
okay.
on the
Well,
file.
all I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it. I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April, and on the 13th of April it gets fixed.
So, Mr. Zahid Ibrahim,
This itself is a vindication of this law.
can be fixed by the Supreme Court itself.
So,
If you point
so
point
all
it
the
out
Parliament
the
is
Supreme
saying,
Court
all the
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
How does the Parliament come in?
Mr.
order,
Zahid Ibrahim,
I
order
can
19
add-
of the Supreme Court rules, order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay. So
Does it
it's a
happen?
question of
I mean-
implementation. So according to you, the rules are already there; they are not implemented.
No, so
if it is incorporated in a statute, it would ensure implementation.
it
Mr.
is not
Zahid Ibrahim,
incorporated in the
Mr. Zahid
statute.
Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which would strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door, which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr. Zahid
The
Ibrahim,
main question is,
Mr. Zahid
the main
Ibrahim,
question
all
here
that,
is
all
whether
that
there
the
is a
Parliament
door.
has done.
Yeah, door is the question that will
Well,
determine.
the Constitution, for the
Zahid-
time being,
Zahid Ibrahim.
does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it
I-
all is a door or not.
Mr.
What comes
Zahid
through the door
Ibrahim,
is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has said. I view it differently. The Parliament, since this court having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is tried to structure the discretion, which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the constitution, in light of this law, who is the master of the roster?
Well, according to one judgment,
No, I'm talking of the law. In light of this law, who is the master of the
I'm
roster?
not sure where the term even master of roster comes
Gone are
from.
the
Who
days.
decides which cases get fixed where, etc.,
The
etc.?
committee decides.
Hmm?
The committee.
No, you're wrong. Committee is the creature and creation of parliament. At its broadest level, this law, this law is a claim by parliament that parliament is the master of the roster. And I'm asking you a question.
I apologize.
You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it. Maybe that those laws, maybe that those laws will be made. Maybe they won't be made. That's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
Yes, ma'am.
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, it is Parliament that is the master of the roster. Now, placed at that level, seems to me that this is directly in conflict, directly contrary to the principle of independence of judiciary. What would you say to that?
Can the master
I
of the
would
roster,
say, I would,
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then they can be fast track cases, election matters, naturally election matter will become redundant after a certain period of time, bail matters, etc. But to see even the cause list of the day and where it goes, I think, and this is the master of the roster speaking, please give me this power so I can use it from the existing Supreme Court. I have this power. I can't seem to find it. Can you help me with that?
And Mr. Zaid Ibrahim, there are no masters anymore in the world. You see, if you look around,
He always wants to undermine my authority.
with respect to
On
the
a lighter
master.
note.
No, but, so I don't see that as a master. So, Mr. Zaid Ibrahim, what I want to say is that if you look at internationally, it's about time we wake up to the world. You see, we have US, UK, Germany, Brazil, Nepal, Philippines, just to name a few. There's no such thing as master of fraud, master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this. You see,
my lord,
with due respect to the master
with
here,
utmost respect, I say we need to wake up to what's outside this room.
You see the, if I may add to that,
And to answer,
under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
yes,
This is not a lifetime appointment.
but while they are
One,
there,
no, just a minute, just a minute, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here, I'm talking even way into the future, they will do whatever they want to do. But that is not the important point. The ephemeral, fleeting, whether it's 1 year, 2 year, 3 year term of a Chief Justice, of a master, if you want to put it that way, in the more traditional sense, that is, in a sense, beside the point. The question is, within the framework of the Constitution, separation of powers, independence of judiciary. Ultimately, who is the master of the roster? And can Parliament lay such a claim and not violate the Constitution? This is the ultimate question.
But if I
Yeah,
could just
may
bring
I-
in another dimension to this, I don't know if you've looked at this new book called Court on Trial, and they've done a data-based analysis of the Indian Supreme Court, where they say that invariably through data they've discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can he can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge. But as a chief justice, he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
Of course it does.
and
let me,
again,
What,
Mr. Zaid
I've
Ibrahim,
also read the book that I've also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters.
Yeah.
If one man can do it, maybe three persons can do it.
your lordship
Maybe
is,
five persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court. But that's practically not possible.
Mr. Zaid
The
Ibrahim,
point is the principle of the thing still stands. My question to you still stands.
I
Yes.
want to have
Please
the
answer
opportunity
that.
to answer it.
Point करें उसको.
The answer is in two. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is this is. Even in Parliament, when this was discussed, it was discussed that the bar has wanted to do this for a long time. PTI is challenging their legal counsel. Hamid Khan was cited in the debate as supporting this law. To answer your question, Parliament does not seek to be the master of roster of any,
Not a
In-
question of whether they seek to be this
or
they
they have
seek
not.
to be- No,
Mr.
sir.
Zaid
The
Ibrahim,
principle that is being established is that they are. Whether they seek it or not is beside the point.
Mr.
This is
Mr.
the
Zaid
core
Ibrahim,
of the question.
I would
in-
humbly
in-
say that it is
Ibrahim,
not.
in
And
most
secondly,
of
secondly,
Mr.
in
Zaid
relation,
Ibrahim,
Just on
Sir,
the
sir, it's
lighter
an-
in
note,
most of the jurisdictions,
the only
the
way I
fixation
cannot
of
read
cases-
into this is to keep my eyes closed.
no, is to not chase
Mr.
shadows. I
Mr.
would say
Zaid
not chase
Ibrahim.
shadows. And just one last thing. My lord, your lordship had said that, oh, chief justices are there for 1 year, 2 year, they go, new chief justice come, and there's no, it's not you're stuck for this forever. But my lord, what do we tell people who had
No,
homes
I,
in
I,
Nasla
I know, I
Tower?
think, no,
What do we
sorry,
tell
Mr.
people
Zaid,
who lost
Mr.
jobs,
Zaid, Mr. Zaid
employment,
Ibrahim,
That is not an
lives,
answer.
property?
Mr. Zaid
There
Ibrahim,
should be a right of appeal.
ये देखिए, let this message not go out from this court that the constitution and the laws of Pakistan are dependent on who the Chief Justice of Pakistan is. This message must not go out from this court. The laws of the constitution and the laws of Pakistan are there, irrespective of the size of the Chief Justice's foot. So let this message not go out that the next Chief Justice can do as he pleases. Absolutely not. Let that be clear that what the law is, what the constitution is not a variable commodity subject to the whims and wishes of the Chief Justice of Pakistan. That must not be so. And if that is so, that is destructive of the constitution. It is destructive of the rule of law. It is destructive of the independence of the judiciary. It is destructive of everything. If we go that far and say, oh, let the next one come, he'll retire 25th October, he goes, the next one will come, he'll do his own way. No, absolutely not. He should follow whatever is the proper method of doing things. It's not, I mean, sorry to say, if anybody thinks in that side, Parliament, or in any other situation that he becomes all powerful, I at least will not let this institution put forward this thing. If we will do as we please,
We
till
are-
when we do. Here we have autocrats writing books, friends, not masters. We don't want to even say that. I am not anyone's master.
All
I am subservient to the constitution and an abd of the Almighty.
Mr.
That
Zaid?
is the place of a judge. It should remain there.
Mr.
It should
Zaid?
not be variable commodity. Oh, the next is just what? How will he do it? So
Mr.
I
Zaid,
don't.
if
This
I
is a
may.
very unhealthy sign. If it is so variable, then where the Supreme Court's change laws. I mean, a law is enacted today. The way it goes up, interpreted by one court, by the other court, by the higher court, by the time it comes to the Supreme Court, takes about 20 years for any law to settle. Now, if it's such a variable commodity that we sort of stump everything and we come 184.3, today the law of Pakistan is
No,
this.
certainly we look for consistency
Mr.
and that's
Zaid
what the
Ibrahim,
legal
I
system
think,
should provide. Yeah,
if
but
I'm not wrong, in most of the jurisdictions, they have adopted objective criteria for fixation of cases and constitution of benches. And they have named it as the natural judge concept. And they have done away with the concept of master of the roster. It's done on an objective basis, laid down criteria, and not on the basis of a discretion vested in one person.
I think it's high time that we bury masters and bring in trustees.
Yes.
In fact, the Constitution starts with that word. It's a sacred trust. Because you have mentioned Islam, but I was surprised nobody else is mentioning Islam. I mean, it's mentioned on the
it to the
streets
extent that
more
it
than
was
it is in the
relevant.
courts of law.
Most grateful, sir. Thank you for the opportunity.
Mr. Zaid,
Please, sorry.
बड़ी इनके जो जितने भी मास्टर ऑफ रोस्टर्स प्रेजेंट और फ्यूचर के होंगे इनसे माजरत के साथ ये देखना है कि इस लॉ में आया ये बताया गया है कि कितने बेंचेस किस तरह बनेंगे या कौन बनाएगा
सर
किस तरह बनने में और कौन बनाएगा में जरा फर्क होगा
वो आप लोग आपके ऊपर छोड़ा हुआ है जिस तरह आपने कहा कि जो अगले आने वाले लोग हैं और जो हैं उन्होंने आप लोगों के ऊपर है ये पार्लियामेंट वहां पे नहीं फैसला होना है आप नहीं करना है ग्रेटफुल मनोज मोस्ट थैंक यू
भाई शुक्रिया
Who do you represent?
My Lord, I represent the PMLN. My concise statement is 8301 of 2023. My Lord, I'm sorry, I have committed the same mistake as some of the earlier councils. जो extracts or foreign judgments थे मैंने अभी दिए हैं.
8301.
I apologize, sir.
अब प्रेसिडेंट बन गया.
Sir, I'll keep a mind of it. In future, sir, I'll be careful of it.
8301 ना तो निकाल लें.
There should be a booklet in front of your lordships and the CMA. That is all I will be relying on. May I?
जी.
Lord, first of all, there's a question of maintainability. At least as far as I am concerned, sir, I'll not be raising that issue. And for the reason that the last time I was on my legs before an 8-member bench, my argument was that due to the public importance and constitutional import of this case, it should be heard by a full court.
चलिए ठीक है.
And
आगे बढ़ें.
sir, now on merit, sir, there are 3 questions to my mind. Firstly, can Parliament legislate regarding practice and procedure of Supreme Court and in any case override provisions of the Supreme Court rules 1980? Number 2, can Parliament create a right of intra-court appeal against orders under 184(3)? And number 3, whether even assuming the above can be done, do the provisions of the 2023 Act otherwise somehow conflict with any provision of the Constitution. Now, before taking your lordships to the relevant entries and Article 191 and so on and so forth, I'd like to make some submissions, sir, regarding the overall conceptual framework within which I view this issue, and also the background and necessity of the legislation, especially since the petitioners and the counsel for the PTI have directly attributed a malafide political intent behind this act, arising from a desire to subjugate the independence of the judiciary. Now, I agree with the petitioners that issues relating to independence of judiciary do directly engage fundamental rights guaranteed under 9, 10, 10A of the Constitution. But there is a crucial difference between all the previous cases decided by this court, Meram Ali, Rawalpindi District Bar, Liaquat Hussain, Al Jihad, etc., and this particular case. All the previous judgments of this court basically deal with external threats to the independence of judiciary. My humble submission is that this case primarily relates to internal threats to the independence of judiciary. It is what Justice Asif Saeed Khosa, as his lordship then was, referred to as the final frontier of judicial independence. My submission will be that the constitutional guarantee of independence of judiciary covers both external independence and internal independence. Now, I'd like to start, sir, by reading two short passages from the article of Justice Khosa. He wrote this when he was a judge of the Lahore High Court. So this is page 1 of the booklet. And if your lordship will see page 4, I'll read a couple of passages from there, and page 6. So the second para, page 4. Now I come to the fourth stage, which I call the final frontier. In my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but now my perspective and angle are slightly different. Having spent a good number of years on the bench, I have seen the system from within, and thus I know and understand a few things which an outsider may not be in position to appreciate. In this background, I intend to share some aspects of independence of judiciary which are generally overlooked. But these aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete, and if I may say so, shallow and superficial. I'll skip a para, sir, to save time, then the para after that. It is some of these areas and aspects, often ignored and overlooked, which I intend to highlight. The earlier stages I have mentioned are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary is achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me of particular importance in this context: independence from oneself, independence from judiciary, and independence from justice. Now, if your lordship will turn the page to page 6. In the first part of the final frontier, he deals with how judges have to rise above their own personal inclinations, ideological inclinations, biases, so forth. And then the second part is discussed here. The second aspect of the final frontier is the independence of an individual judge from the undue pressures of his peers and from unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, i.e. the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors, and an individual judge starts abdicating his decision-making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision making in sensitive matters because that judge is not likely to toe the line of the institution. Both these factors, which may be unthinkable in the civilized world, are unfortunately real possibilities in some other parts of the world and completely undermine the notions of independence of judiciary. Apart from the above, concentration of powers in the hands of the head of a judicial institution regarding constitution of benches, allocation and distribution of cases amongst benches, attaching priority to different kinds of cases, and geographic transfer of judges is an issue which has raised eyebrows in the past and can also resurface in the future. A possible misuse of such powers by the head of a judicial institution can effectively render the independence of an individual judge to be of no practical utility or benefits to the citizens at large. Such a threat to independence of judiciary has its origins within the judiciary itself, and any degree of independence of judiciary painstakingly achieved through all the other stages mentioned above can effectively be neutralized through machinations from within the judiciary itself. In this context, I feel that independence from judiciary in the above mentioned areas may be a sine qua non for reaching the final frontier of independence of judiciary. Now, of course, the author of this article eventually adorned the office of the Chief Justice of Pakistan. But nonetheless, for whatsoever reasons, no structural change could be brought about to achieve this final frontier of judicial independence. Now, this concern about the untrammeled powers, the untrammeled discretion of Chief Justices is not unique to Justice Khosa. Another future Chief Justice has also.
Mr. Salahuddin, it is a person-specific argument which you are raising before us.
Not at all, sir. What I'm saying is that this argument, this concern, has been raised by multiple of your lordships.
The issue before us to come to that.
Yes, the issue that I'm coming to, sir, is that there have been multiple concerns expressed by the judiciary itself about the concentration of powers in the office of the Chief Justice and the potential for abuse of those powers and the perception that it creates in the general public. Now, those are exactly the issues when Parliament is being accused of acting with.
The matter relates to the institution.
Yes, sir.
Please, we are sitting to hear you.
Let's go for let's look at the law. Your point is taken. You feel that there are voices coming from the bench. Fine, point taken.
Mr. Salahuddin, whatever you are saying assumes competence. That's the
I'm
one
coming,
of the key points over there.
I will come to
All
both
of this
those.
may be right, all of this may be wrong, some of it may be right, some of it may be wrong.
I
You
will-
tell
I-
us about competence.
I will address the issue of
जी,
competence if your
ये-
lordship will allow me.
ये तो चेहरे किसी का अपना व्यू है होगा.
Sir, bilkul. I will cite, I'll just cite, not read from them, but I will cite the different judgments in which at least I think, if I'm counting correctly, 10 members of this present bench have raised concerns about the concentration of powers in the office of the Chief Justice. And my submission would be that that in itself dispels any argument of malafide.
Does that in itself confer legislative
No, sir, it
competence
does
on
not. It
Parliament?
does not, and I will deal with those
आप
independently.
उस तरफ हैं.
I'm just completing this, sir.
Kindly tell us what you say about who is Parliament the master of the roster?
Yes,
As a matter of principle.
If you're, I will come to
उस
that,
तरफ
sir.
आइए ना, ये
I
तो
will
चले.
come to that,
किसी
sir.
की कोई व्यू है, किसी की क्या व्यू है.
Yes, I will come to that. I just want to quickly cite those judgments, sir. PLD 2019, Supreme Court, page 183.
183.
Yes, sir. PLD 2021.
And what proposition is this?
Sir, these are all judgments and dissenting notes and additional notes in which different judges of this court have on various occasions
I think
raised.
I think you should be a bit careful. With all due respect, I don't
Ji.
want to stop you from making your submissions, but you're treading on relatively thin ice here in the sense that if you're quoting a retired judge, that's one thing. But if you're quoting sitting judges in this particular context before a full court, when the very competency of parliament is under challenge, I think it's better for you to just focus
Hello.
on. I hope you understood what I'm saying. I don't want to say anything
I'm
further.
not, and that's why I'm just
It's not.
placing the.
Please don't.
I would like to hear what you're
Views have
saying.
been expressed. They have been
I would
I'm
like to
placing
hear what
those
you're saying.
judgments before
Ji.
your lordships. I'm not.
Citation
Can you cite them?
Any extraneous
उसको
material.
जरा
I'm not-
नजर लगाओ।
Please cite them. Please cite
Citation
them.
बताइए,
Sir,
citation।
PLD 2019, Supreme Court 183. Then PLD 2021, Supreme Court 446. There is a dissenting note in that.
कोई relevant pages आप नहीं बता रहे हमें. Relevant pages.
Sir, I'll dig them out then, sir. PLD 2021, Supreme Court 446 में, sir, it is.
इसका टाइटल केस का क्या है?
Sir, ये PM's discretionary fund है. The earlier one is.
चलो लिख के दे देंगे pages.
जी, मैं दे देता हूं,
आप
sir.
citation
जी,
से.
मैं दे देता हूं, sir. Then there is PLD 2023, Supreme Court, page 306. There is PLD 2022, Supreme Court, page 3006.
2023 Supreme
20,
Court.
PLD 2022, Supreme Court 306.
23 का भी आपने बताया ये
जी,
22
sir,
का भी
23
same page.
जी, नहीं, PLD 2023, Supreme Court 306 and PLD 2022, Supreme Court 306.
दोनों both have the same
जी, sir.
page.
And उसमें this second one, sir, जो 2022 का है, that is Suomoto case number 4 of 2021. And in
चलिए वो
that,
देख लेंगे ना. Let's just
I
cite
rely
them.
on paras 53 and 56.
53.
अभी citations ही दे दें।
Cite, that's it.
And sir, there is SMC number 1 of 2023. There are 3,
Reported or not reported?
sir, not reported as yet.
SMC number.
1 of 2023
ठीक.
and SMC number 4 of 2022. Now, in addition to that, sir, the bar councils and bar associations have obviously been passing resolutions on this issue for
With
almost
all
a
due
decade.
respect, again, to the
BBC
bar,
can do that.
bars
Yes.
and councils.
Main question
What
is
does that have to do with
My lord,
competence?
there is.
I mean, are we supposed to be swayed by, with all due
Not at all.
respect to what, those are extra judicial
Not at all.
statements.
Not at all.
Kindly
Your
talk the
lordship-
language of the.
Your lordship will appreciate.
See,
Mr.
कानून की बात कीजिए, ये तो नहीं कि-
Salahuddin, there are only two questions involved here.
Ji, sir.
One is who is competent, question of competency. And two, if we come to the conclusion that yes, there is competence, then you have to convince us that the law as framed is not in conflict with any provision of the Constitution. If you would kindly address these questions, I mean, most of your case would be
My lord, what
encompassed in that.
I'm grateful to your lordships. What the main challenge by the petitioners has been on two grounds. One, that it infringes, the legislation infringes the independence of judiciary. That is one completely separate issue. And the second is that that it is beyond the legislative competence of Parliament. Now, in the legislative competence issue, obviously, whether the law is an excellent law or a terrible law is irrelevant. I will gratefully adopt your lordship's formulation on that. But as far as the challenge on the basis of independence of judiciary is concerned, the merits and substance of the law and its background is very relevant. That is why I'm briefly, I'll come to the legislative competence too. Sir, if your lordships will see that I'm not going to go through the resolutions or anything, but they're at page 171 to 185 of that booklet.
But
And if your lordship,
one thing, I've seen judgments of this court which have cited news reports for various, relying on various things, and consequences have flowed from those news reports. So I, for one, do respect what the the highest bodies of lawyers have to say, whether it be the Pakistan Bar Council or the Supreme Court Bar Association, most ably represented by Mr. Abid Zubairi. So if you want to file those, I mean,
They are-
I would place greater credence on them than on newspaper reports which have been taken note of and judgments passed by relying thereon. So if we keep talking about this chariot perpetually ad nauseum, the two wheels of the chariot. Now let us see this chariot work.
it is, in my humble submission, is
But I
that
think
they are
competence,
relevant.
I think competence of a law is never been, as far as I
I
could
certainly
recall,
want to hear a person's point of view.
is decided on the basis of newspaper reports. Those are other contexts.
Yes, legislative competence is a separate issue. I'm dealing right now with the independence
Well,
of
right now
the
you-
seeming
No,
infringement.
but independence of the judiciary itself is, if it is competence is not just legislative competence. Competence is also competence vis-a-vis other provisions of the Constitution.
My lord,
And what the people perceive independence to be, and more so than the people, those dealing with the law, which is the legal community. So I definitely want to see the perception of independence. I mean, it may be very independent, but people may think it otherwise, and vice versa. It may not be independent, and people may think it very independent. So yes, you don't have to spend a lot of time on it. If you can just refer to them or give it to us.
They are at pages 171 to 185. And they are resolutions that what I was able to discover were only dating back till 2018. But I understand PBC has filed something going back to 10 years ago. But there is just one aspect of those resolutions that I would ask your lordships to consider. And that goes to some of the questions that have been raised. If your lordship sees that initially in all those resolutions, the request was for this court to amend the Supreme Court rules to regulate the suo motu power and to regulate the master of roster power. That was the demand for the major period. Eventually, there has been a change in the tone and direction in the last 2 or 3 years, which has then now, in the more recent resolutions, asked for Parliament itself to directly act under 175 and 191. And presumably, the change in direction was because there was no effective response from this court on its administrative side. I'll move on, sir. Now, Justice Hilali had asked two pertinent questions, and Mr. Zahid Ibrahim had also pointed out the need to look outside. And those two questions was one, if the CJ's power to form benches and assign cases was taken away, what would be left of the CJ's office? And secondly, how the formation of benches and fixation of cases is dealt with in other countries. Now, the answer to that first question is that there are certain specific powers and rights of the Chief Justice that are enshrined in the Constitution itself. There are about 9 that I can think of. I'm not going to go through them all, but they are there in my concise statement. Apart from the ceremonial powers, there are 9 concrete powers. The power to make benches and assign cases is not a constitutional power at all. It is not mentioned anywhere in the Constitution. In 1935, in the Government of India Act, it was indeed a constitutional power of the Chief Justice. In the 1956 power, there was a direct provision in the 1935 Act. In 1956, that power was moved to the 3rd schedule of the 56 Constitution and made subject to rules and then by virtue of Article 177 made subject to Act of Parliament.
This was
After
1962,
1956.
56.
Third schedule में थी power that the Chief Justice may subject to rules, form benches, etc. And that was in turn subject to Article
What about
177.
the power under the Government of India Act 1935, which was the first constitution of Pakistan from 1947 through to 1956? How was the power there framed?
In the 1935, I'll just read the exact.
What is the section?
Ji, sir.
Read section 214.
It is 2143. Subject to the provisions of any rules of court, the Chief Justice of India shall determine what judges are to constitute any division of the court
Kindly read subsection.
and what judges are to sit for any purpose.
Power of the roster.
Ji, sir?
The power of the roster.
Yes, it was there.
Now, actually, the power of the roster goes much further back in time. Have you seen the Indian High Courts Act of 1861?
No, sir.
Let me tell you where this power comes from and how it ends up in the judicial case law. You see, after the British took direct rule of India in 1858, one of the first laws that was made in 1861 was in relation to the power to issue letters patent to create high courts. Madras, Calcutta,
Yes.
Bombay, and all that. So this is something that goes back to the very beginning of British rule in India. Now, this provision, this Act of 1861, also had something to say in relation to that. Let me read out to you section 14 of this Act, 1861. Because at that time, there were only high courts, right? Federal court comes in 1935. The Chief Justice of each court shall from time to time determine what judge in each case shall sit alone and what judges of the court, whether with or without the Chief Justice, shall constitute the several division courts as aforesaid. So the Chief Justice as the master of the roster is a power that goes back to the very beginning of British rule and whatever follows thereafter. This position continues for several decades until we reach 1935. In between, we have the Government of India Act 1915. वो आपने देखा है? नहीं. उसमें भी section 108 था, which was in exactly these terms. ठीक है? अब आपका आ गया 1935 का Government of India Act, where you just read out for us subsection 3, right? Subject to rules made. But the rule-making power under subsection 1, legislature had no interference with that.
Yes, sir.
Then we have the
But the Governor General did. It was with the approval of the Governor.
approval.
Yes.
He couldn't make them, he could only approve
Yes, but the approval in his discretion.
as originally contained.
My lord.
Now we come to the 56th Constitution, उसके provisions आपने हमें बताए हैं. Then we come to the 1962 Constitution, where the article takes the shape that it now has. But the 62 Constitution, as I said when Mr. Ibrahim was arguing, in the third schedule, it had a specific legislative entry for Supreme Court.
Yes.
Interim Constitution reverts structurally to the position of
Government in India.
1973 Constitution does that. Now, it seems to me that if you look at the grand sweep of constitutional history, starting from 1861 onwards, the 56th Constitution, which is perhaps the high water mark of legislative interference with matters relating to the power of the roster, out of those centuries-long period, this is a very narrow window, hardly a few years, right? This expanse, which I think is about 150, 160 years.
निगरान वज़ीर आज़म अनवारुल हक काकड़ की ज़ेर सदारत वज़ारत मज़हबी